So my job today is to talk to you about what we've heard from the Court of Justice this year on data protection. But it's been a very busy year. If you look at the publication that accompanies this event, we've summarised 12 decisions there, and that's not all of the data protection decisions that we've had. So obviously, I'm not going to cover all of them. What I've tried to do is pick out some things we've learned that will have a practical application for you as practitioners. And in terms of where to start, I thought I'd start where I left off last year. Because last year I was talking about contractual necessity as a lawful basis for processing. And there was a lot of debate going on about where you could use it. And we finished by kind of gazing into the distance and wondering what was going to come over the horizon. And now we know. So we've had this decision, Messe- and Bundeskartellamt. It's a very wide-ranging decision. It deals as well, for example, with the interaction between competition law and data protection law. But I'm just focusing on 2 points from it, which is what it told us about when we can use contractual necessity as a basis for processing. So the first thing is the court said the processing must be objectively indispensable for a purpose that is integral to the contractual obligation intended for the data subject. And you may recall that this context was about using data to target advertising in the context of delivery of a social media platform. And you may not be surprised from that condition that the court said that was not objectively indispensable. But if you take it out of that context, it's a very high bar to clear. And in addition, it said if you've bundled a number of services together, you've got to judge contractual necessity in the context of each of those services separately. So again, it's making it much harder to rely on that lawful basis. And I'd suggest that if you are operating in Europe and relying on contractual necessity, you might want to review your processing and see if it still qualifies. Moving on next to data subject access requests. There's been a lot of enthusiasm for these in Germany and Austria, which has resulted in quite a lot of guidance for us. So first up, the court has told us there's always been a bit of a puzzle when it says that data subjects have a right to know recipients or categories of recipients. Who decides which you tell them? The data subject has a right to a list of the specific entities which you're sharing data with, not just the general categories, but the names of the companies. And that does kind of make sense, because if I don't know who you've given my data to, how can I exercise my rights? A further clarification about recipients: an employee of the data controller does not count as a separate recipient. And again, that makes sense. They're just part of the data controller. Control hasn't passed to anybody else. So in that case, the data subject was saying, I want to know the names of your employees who've looked at my data because they are recipients of my data. And the court said, no, they're not. We've had decisions in the past telling us that the right to data is a right to data, not documents. A decision this year said the right to a copy means an exact and complete reproduction of our personal data, not just a summary or an overview. The court did put a bit of a spin on that, saying it might actually be necessary to provide extracts or context, not just a literal copy of the data, but a bit of information around it, if that's necessary to ensure that the copy is intelligible. And it placed particular emphasis on that in a later decision where it was looking at medical records, and said it's particularly important to provide that context when disclosing data around the medical record, if that's necessary to make it intelligible. That particular case about medical records concerned a German law which gave a right to a copy of medical records, but said that the healthcare provider could be reimbursed for providing the copy. And the National Court said, hang on, how does that fit with the right to a copy free of charge under GDPR? And the court said, it's a right to a copy free of charge. The healthcare professional is not entitled to claim reimbursement, notwithstanding the national law. They did also, in that case, confirm that motive does not matter. You do not have a right to ask about the data subject's motive. So we've all had those cases where you know you've got the request from the data subject because they're hoping to find a smoking gun to sue you for unfair dismissal, for example. That does not matter. They have a right to a copy of the data regardless of motive. Moving on, what we learned about joint controllership, and I'd say here that this isn't something new that we learned, it's something that was confirmed that we knew already, which is that the Court of Justice will interpret joint controllership very broadly indeed, and this was just another example of how you might get caught. And so this particular scenario was back in the early stages of the pandemic, and a Lithuanian National Health Centre decided to commission an app to monitor exposure to COVID. Remember those? So it commissioned a development company to develop this app. They had a meeting with them to talk about what the app was going to do. The development company cracked on, developed the app, launched it, nearly 4,000 people registered, and then the health centre said, oops, we haven't got any budget for this, we can't buy it from you after all. Subsequent to this, the National DPA fined them both for GDPR infringements as joint controllers. And the health centre said, but we don't own the app, we've got nothing whatsoever to do with its operation, and we didn't authorise them to launch the app. We can't be a joint controller. And the Court of Justice said, yes, you can. You entrusted somebody with developing this app. You helped determine the means and purposes of processing because you attended these design meetings. So you can, in fact, be a joint controller. If perhaps you'd jumped in and prohibited them from launching the app, we might have come to a different decision. But no, you can be a joint controller. So a bit of a cautionary tale there. And if you are interested in this area, Bristow's actually has a podcast we do on data protection called Legitimately Interesting. And the next episode, which is out next week, is Jamie and Hannah talking about joint controllership. So go listen for more exciting joint controllership discussion. I'm going to skip the next one in the interest of time and move on to what we learned about compensation. And these were a couple of decisions around when people can claim for compensation with non-material damage. So always a bit of a tricky one. The first one was an Austrian case, a marketing company that had inferred that the data subject had an affinity with a particular political party. And when he found out, he was very upset about this because he didn't. And this caused him great upset, a loss of confidence, and a feeling of exposure. But the court noted that no harm other than those adverse emotional effects of a temporary nature had been established. And it turns out that in Austria, you have to establish a threshold of seriousness to claim damages. And the court was of the view that this temporary adverse emotional effect was not sufficiently serious. Did that matter? Well, no. Because the Court of Justice said, if you're looking at non-material damage, GDPR does not impose a minimum threshold. So if he could show distress, he was entitled to compensation calculated on the basis of national rules about compensation. Oh, sorry, forgot that one. Then the second one, a very common scenario, situation where there's a data breach, you know your data's been nicked, but there's no actual evidence of misuse, but you're actually rather worried about whether somebody is going to misuse it. Does that count as non-material damage? And the court said it can do. The national court has to verify that that fear can be regarded as well established in the circumstances, but it can potentially count as non-material damage for which you can be compensated. And then one last point, which is what I learned from having to reread 12 European Court of Justice decisions in 2 days. And when you read them like that, all close together, you start to notice things differently. And you start to notice the impact of repetition and the fact that in every single case, the court is going back and saying, oh, well, we're thinking about this. And while we're thinking about it, what's the idea behind GDPR? And the purpose of GDPR, Recital 10, it's to guarantee a high level of protection to natural persons with regard to the processing of personal data. And I think in the UK, we don't like to get philosophical about these things. And we tend not to go back to first principles like that. But I think this is a useful point to bear in mind. If you're operating in the EU and you're thinking about doing something and you're thinking, what's the DPA going to think about this? What would the Court of Justice make of this? Which side will they come down? It's useful to remember that their starting point is going to be a high level of data protection when they're making those decisions. Thank you. And I will pass over to Elisa.